Okay, so everyone, this is our second part in our four-part series with the Department of Corrections. And this is Stacy Crabtree, and I think she's somebody that a lot of you have probably wanted to hear from, and a lot of you who might want to call her after this presentation. So she's been with DOC for 17 years, and in various positions, but the most important one that she has from our perspective is that she currently oversees a staff of about 100 in the areas of time computation, offender information records, protective custody, classification, identification systems, intake, earned incentive program, population management, movement inmate correctional plan, and the 287G ICE program. Not sure how you do all that.
We have good staff.
Okay. She does have a BS in criminal justice and also an MBA. And then Herb, if you could come up just for a moment so I can introduce you.
Stand by, Stacy.
Okay, and this is Herb Haley, and he is actually going to be presenting at the next BrownBag. And he is somebody whose phone number you're going to want as well, because he's the administrator of time computation unit. And what they do is they review all the court documents, they audit records, and they calculate release dates. So when you have questions about pre-sentence incarceration, I don't know, I'm sure many of you have gotten letters from inmates about you've miscalculated my pre-sentence incarceration and that sort of thing. He's also going to go over a number of errors that judges have been making in their minute entries. And we're talking statewide, right? Not just those of us in this room.
That's right.
Okay, and try to help us avert disasters in the future. So thanks for coming today, Herb. We look forward to seeing you next time. And Stacy, go ahead. Thanks for coming.
Thank you. Good afternoon. Several areas to cover. I'm going to go basically from the time the inmate walks in the front door from county to the time he goes back into the community and what processes happen in between. So we'll look at our intake processes, our classification system, our corrections plan, and our earned incentives plan, and the programming part will fall into the corrections plan area. I'm going to start by just going over some statistics, and this is based on fiscal year-end fiscal 2013. In fiscal 2013, we had 18,677 new admissions, most of which, as you can see, come from Maricopa County, followed by Pima. Within those new intakes, 69% of those are brand new court convictions. 16% are our community supervision violators. 14% are probation revocations, and the 1.2% other, we do a lot of interstate compact with other states or with the federal government, so those kind of fall in that category. The average length of sentence that we've seen in the last fiscal year was about 24 months. As you can see, we released a lot of inmates too. 17,868 inmates were released. 67% of those were released to our community supervision. Our current citizenship distribution, we have about 12.4% of criminal aliens, and that has gone down from about 14% last year. So we're seeing a little bit of a decline in that. Our current population, month-end August of this year, this is just kind of a breakdown. We have about 36,000 adult males, 47 male juveniles. 3,600 females with 4 juveniles. Current death row, 120 males, 2 females. And then kind of a breakdown, life sentences, which includes natural and 25 to life. Sex offenders, about 5,800, and we'll go into more detail what our definition of a sex offender is later on in the presentation. I think our STG group is already presented, or have they? No.
That was the first one.
Oh, the STD.
Yeah, okay. Currently, we have about 331 validated members. His numbers may be a little bit different depending on what time of the month we pulled the stats. Our biggest population management issue right now is our increase in the number of inmates that are going into protective custody. We're at about 3,400, which is 9% of our male population. That has increased. In 1997 was Doe v. Stewart. We were under a class action lawsuit in 1997 regarding our PS review process. It was Doe v. Stewart. Under court monitoring for several years, since 1997, our population in PS has gone from 1% to 9%. So it's a huge housing and management issue for us right now. And we currently have about 5,700 inmates on community supervision. This is basically a map of all our complexes. Each complex has several different units, which houses several different custody levels and several different types of specialized populations. The ones highlighted in yellow, those are our private prisons. So we have Kingman, this is Marana, which I know everybody in here knows about Marana. And these are our DUI facilities. This is Phoenix West, and this is Florence West, located in Florence. And then we have a sex offender unit also there. The blue units are our complexes. So we have Perryville. This is where all the female inmates go. We have our Alhambra Reception Center, Lewis, Yuma, Tucson, Douglas, Safford, Florence, Iman, and Winslow. And the numbers are the different types of custody levels or different types of populations that each complex can house. Right now, all our sex offenders are housed in Florence, Iman. That's where all the sex offenders are. All our protective custody inmates are housed in Lewis and max custody in Florence. Those are our two big specialized populations. We have your validated STGs, death row. They're obviously all in Iman complex and our Supermax. The blue, the ones identified in red, this is what we call corridor units. So if the inmate has any type of medical or mental health issues that require specialized mental health treatment or specialized medical needs, they would go to one of these complexes highlighted in red. Basically because they're in close proximity to hospitals and other type of outside care. We do have, and we're increasing the number of what we call inpatient care type units. Our population is getting older and they're requiring a lot more medical assistance. And we're also creating a lot more what we call mental health treatment units, where we offer very intensive mental health treatment. The Phoenix complex is our reception center, but it's also our licensed mental health center. So if the inmate's court ordered for any type of treatment or forced medication, they're your most chronic mental health inmates. They're going to be housed here in Phoenix. So what happens once the inmate's sentenced? Once the inmate is sentenced and we get notified from the clerks, we bring the inmate into our reception center within 1 day. Now, we don't have any control on how long it takes for the court documents to get to the clerk and all the paperwork gets together, but once we're notified, they're brought in within 24 hours. Where do they go? The adult males will go to our 24th Street in Van Buren, Alhambra, Phoenix. Adult females all go to Perryville. Our minor females go to Perryville, and our minor males go to Tucson. When an inmate's convicted of death row, they're usually transported straight to Iman. They really bypass our Alhambra Reception Center because we just don't have the ability to house them there. Inmates that are sentenced to life are also brought into Phoenix, but they're transported out same day. We don't keep them there. Yes?
What age is your minor? What do you guys consider a minor?
Under the age of 18. Once they turn 18 midnight that night, they're moved into a transitory bed and then moved to an adult unit. The average time for males that they spend at the reception center is really 3 to 5 days. There are some exceptions. If the inmate needs additional mental health or medical screening, medical will put a hold on that inmate and they may stay a little bit longer. But basically it's usually 3 to 5 days and they're transferred to a permanent unit. What happens at intake? Obviously the first thing we need to make sure we have the right inmate. So obviously law requires that the index finger be placed on the court document. When they come in, we'll do a fast ID, a 10 print, run that through AZCorrections and make sure we have the right inmate. We do the DNA testing as required by law, the mug photo interface, which is downloaded into DPS, and then they go through our ICE process to determine citizenship. There's a brief review to make sure we have all the right court documents. The inmate's interviewed for any type of personal history, emergency contact, that sort of thing. They go through a very in-depth medical and mental health, dental, vision, PPD test. They're also tested for education to include special ed needs, a spiritual assessment, something that's just now starting, is now we're required by federal law to be in compliance with the PREA law by, I think, January of this year. So we just recently implemented a PREA assessment at our intake centers. And then finally, classification.
Stacey, what is PREA?
The Prison Rape Elimination Act. And all prisons, all county jails, everybody has to be in compliance, I think, by January of this year. And then finally, classification to determine custody level. Now, once we determine custody level, we have certain complexes that we can choose from. We know where all our medium levels are, all our close, but we also look at the inmates' education needs, their mental health, medical needs, sex offender status. So there's more, when we finally determine final placement, there's a whole bunch of factors other than just custody level that we will look at. For example, not all of our institutions offer special ed. So if an inmate needs special ed, I need to find the right custody level and the right unit that can meet that inmate's needs. So it's kind of a puzzle to find a placement for an inmate. The department entered into a 287G program with ICE back in, I want to say, 2005. We're one of only 4 left in the state of Arizona, so we're very proud of that. And basically what the MOA does is it allows us to certify our CO3s to do the duties of an ICE agent, which has saved both ICE and us a lot of time. So when the inmate comes into Alhambra, they will go through the federal databases and the ICE databases to determine what their citizenship status is. At that time, they will issue either the deport order or the detainer, whatever the case may be. Basically, since we started this, we've assisted in ICE in eliminating their backlog of issuing deport orders, because now our officers can assist that upon intake. In fiscal 2013, 1,900 criminal aliens were transferred to ICE. Out of that, 709 were qualified for the 1/2 deport. And I know one of the questions were, what is the criteria for 1/2 deport? The statute's 41-1604-14, and basically here's your, whoa, wrong button. Here's your criteria. They must have an order of deportation, first of all, from ICE. They have to serve 1/2 the sentence imposed, 3, 4, 5, 6 class felonies only, no Chapter 13-11 offenses, no sex offenses, no serious offenses, and they can only be released at 1/2 one time. Now, if when they're deported at 1/2 and they come back, they owe us the remaining of that sentence day for day. It could be 20 years later. There's no time frame. If they ever come back, they owe us the remaining of that balance of that sentence. If they're come back, they serve the remaining balance of that system, they're deported again, they come back and commit another crime, they're not ever eligible for this type of release again. It's a one-time deal. Okay, classification. Our system was just recently validated by NIC, which is the National Institute of Corrections, in April, so another thing we're very proud of. There's 2 components of our classification system. There's the custody level and the internal risk level. The custody level basically tells us what custody level for public safety does that inmate need to be housed at. The internal risk level, it looks at public safety factors, but it also looks at internal risk factors such as institutional violence, housing matches, program issues, etc., job assignments. So those are the 2 components of the classification. This is just kind of a description, and I'm not going to read it word for word, of our 4 different custody levels. We have maximum, close, medium, and minimum. Maximum being our highest custody level. And basically these guys are either, most of them are single-celled. Some of them can be double bunked depending on their violence history. They're usually locked down 23 hours a day. They can get out 3 hours a week for shower, phone calls, non-contact visitation. Now we're making some changes in that. We've already implemented what we call kind of a two-phase maximum custody as a step down to a lower custody. So at some of our max custody units, the inmates are now allowed to come out in small groups. They may be able to come out and do more programming. We're offering more programming for max custody. Very staff intensive, but we're starting to kind of get them ready to step down to our lower custody or back into the community. So that's really one of the big issues the department's doing right now. You can see basically what the demographics within maximum custody, 65% of them were convicted of a violent crime. A lot of gangbangers in that custody level. Average length of sentence 13 years. The next custody level is close. It's a step down from max. They're allowed out of their buildings in large groups. It's very controlled movement. They're all double cell environment. There's no dorms in close custody, but it's kind of a step down from close custody. Again, kind of a breakdown of what types of crimes and sentencing. Medium is basically more an open yard, mostly dormitories. We have some cell environments, medium custody, but less controlled movement. And then finally, minimum is our lowest custody level. These inmates, these yards are wide open. Some of them don't even have, I don't know if anybody's ever been to the Papago unit in Douglas. It's an old hotel. There's not even a perimeter around it. So those are your very low, non-violent type offenders. These are the guys that can work out in the community if they meet certain criteria. You see the guys working at Capitol Mall. Those are our DUI inmates from Phoenix West. So those are your least violent offenders. So what do we use to determine both the custody and the internal risk? And these are the areas we look at. These are factors determined nationally to be the most prevalent indicators of violence and public risk. So we're going to obviously look at their current conviction. And inmate comes in with multiple convictions. We're going to score him on the most serious based on felony class and statute. We're going to look at all his previous convictions, whether they're with Arizona DOC or if they're with another state or the military or the federal government or juvenile. We look at all of that. And it's scored based on the seriousness of the prior offense and how long ago it happened. Obviously, we look at if the inmate has any escape history. That could be with us, another jurisdiction, county jail. Does have to be from a secure perimeter. Gang affiliation status, whether it be a street gang or one of the department's security threat groups, that's a big driving factor for institutional violence. Age, usually the younger the inmate, the more likelihood he's going to get involved with some negative behaviors while in prison. So we look at the age. And for reclassification, if the inmate completes programming that he is required to take, that can help reduce his overall custody level. So each of these categories are scored and weighted, and it gives you basically a final overall custody level based on each one of these individual factors. Yes?
Current age, is it younger or older? Is it older more likely to be into a minimum custody as opposed to a younger?
The older you are, the lower the score in that category. So each time an inmate, and they're grouped in category 18 to 25, and we have groups, but as each time the inmate gets older, the points in that category reduce. It may or may not affect the overall custody level, but yeah, the older you are, the more likelihood your custody is going to be lower overall. This is objective. This is an automated tool. So once we enter all this information into the system, we then have the officers really, and this is where the pre-sentence investigations are so important. We're seeing more and more of them that are being waived. Well, the pre-sentence investigation, this is an objective scoring. But we also want to use our own knowledge. We look at the PSI. Is there any aggravating or mitigating circumstances? The inmate may score out as minimum, but there may be something in that PSI that, you know, that may aggravate that, and I may want to override that inmate to a higher custody. The PSI also helps us in determining programming needs. We teach a class with the public defenders, and I mentioned to them, please don't waive the PSI or request it to be waived, and they automatically think it's going to harm the inmate. It's going to make us, you know, higher custody. That's not always the case. It may mitigate. It may, you know, lower the inmate's custody level, and it may help us determine what type of programming needs he has. So the PSIs are very important. We have what we call non-discretionary and discretionary overrides, and as I just mentioned, if there's mitigating or aggravating circumstances, I can either override that custody level higher or lower. The non-discretionary overrides are basically no matter what, the inmate cannot reduce below these levels. So if the inmate comes in with a death sentence, he's going to be max custody forever, no matter what that raw score tells me. Inmate sentenced to life, this is really their step down. They have to serve 2 years in maximum, 3 years in close, and then they can go down to medium, but an inmate sentenced to life can never reduce below medium custody. Any inmate having more than 5 years to serve cannot reduce below medium custody. So they're not allowed to go to minimum until they're under that 5-year threshold. If the inmate is validated as a security threat group, they're maximum custody. If they choose to renounce, and I'm sure our STG covered what that means, they then can go to close. They're automatically placed in protective custody, and they can never go below close. But it's a mandatory placement in PS. If they have a current conviction for a felony sex offense, never can go below medium custody. Felony detainer of any kind will keep them in medium custody. And if their internal risk is 5, that's telling me that guy is very violent inmate. We're going to automatically put him in max custody. And I'm going to go over this sex offender stuff. We have several categories of sex offenders. And basically, here are the different categories. Inmate comes in for a current conviction. He's going to be a status A, and he automatically is placed on a sex offender unit. He has no choice. He's going to a sex offender unit. If he comes in, let's say for ag assault, but through the PSI and or the court document cites sexual motivation, he is interviewed at reception and he's given the choice. Do you want to go to a sex offender unit or do you want to house GP? A C is a prior conviction for a sex offense. A D, a prior that's not a sex offense but sexually motivated. We look at misdemeanor convictions, felony arrest, no conviction, and an N is no history. So again, status A, automatically placed on a sex offender unit. A through F, they're all interviewed at reception and they're given the choice. Now once they go on a sex offender unit, they're never coming back off because they're already labeled now. Some inmates come in and they think, well, we're going to like a sex offender unit. They get there, they hate it, they want to come out. They're not coming out. About 4 years ago, we noticed that a lot of inmates that had been sentenced to child abuse or any crime that was enhanced by dangerous crimes against children were getting assaulted just like our sex offender population was. So we also give them, they're going to be a status N, but they're given the option at reception to choose to house on a sex offender unit because they're treated by the inmate population like a sex offender is, and they were being seriously assaulted.
Question?
Yes.
On that, I've had some defense counsel ask me to seal the sentencing minute entry because it has either a sex offense in the description or DCAC. Should we be doing that, or what is?
I would not I mean, we do this for the inmate's own safety. Because with the age of the internet, or we're going to run criminal histories anyway, and not all that information may be available, but I'll be able to find out if that inmate's ever had a prior through a criminal history check.
So if they have a sentencing minute entry that has that information on it, and another inmate gets that, is it true that that's precarious for that particular?
That is true, and we've had a couple where that information was accidentally placed on the wrong inmate's court order, and that inmate was assaulted. So I misunderstood your question, I apologize, but yes, putting detailed descriptions of that in the court order can sometimes cause the inmate some issues. On the other hand, it's critical that we know that, it's better just to cite the statute, because if the inmate is required for GPS, it's going to affect custody level, it's going to affect release. So we need the information, but not the descriptive. We see some very descriptive stuff in the court documents.
So reference to just the statute is enough for you to know what it is?
Yes.
And we have to at least, if someone's being in DCAC, it gets its own little sentencing structure, so there's no way around labeling it a DCAC.
And that's fine. And again, they're given that option, so a lot of them will go to a unit. And really, dangerous crimes against children isn't a real big issue. A lot of them choose to house GP. But the ones we're seeing is, the actual sexual assault, that kind of stuff where, the inmates, whether you put them in the court document or not, with the age of the internet, the inmates are getting the information. The cell phones, but we need to know the basic statutes at least for classification and release purposes. Status A through D, those inmates can never reduce below medium custody. They don't necessarily have to be housed on a sex offender unit, but they're never going to go below medium. And then if an inmate, in A through D and E, none of these inmates are eligible for the early 90-day TR. And I think one of the questions that was sent in is, I think an offender had asked the question, or had made the statement that he did not get his 85% release date because he was a status E. The 85% that he's referring to, and it's not a true 85%, is his earned release credit date. That's our mandated statutory release. We can't hold the inmate past this ERCD. Few exceptions, mandatory literacy and refusing to sign conditions. But what that inmate was talking about was that early pre-ERC 90-day release. They don't get that if they're a status A through E. Any questions on the sex offenders? Again, this is probably covered, but this is just basically our current prison gangs that have been validated. The old Mexican mafia has now what we've been called decertified. There's only 6 left in our system. So basically what that means is we're not validating any new old MA. Our biggest gang right now is the new MA and the AB, probably the most violent right now also. These are ones that we are considering possibly validating because of their current activities in prison. And again, I'm sure STG covered this, but once you're validated, the inmates have 3 choices. They can remain validated, stay in max custody forever. They can choose to debrief, which means basically they promise they'll, no more gang activity, and they'll provide us intel on other high-profile gang members, which is why they're automatically placed in protective custody. Or we now have what we call a step-down program. Basically, they agree also that they're done with the gang activity, but they're not going to provide us any intel. So they can come out of max, go to close, but they're not placed in protective segregation. On the internal risk side, if any inmate, these are your minimum, if they're minimum custody, which these are the inmates who could possibly go work in the community. Well, not every minimum custody inmate is going to be eligible to go out and work. Criminal aliens are not going to be working out in the community. So this is what we call the non-discretionary. So if the inmate gets down to minimum custody, if they meet any of these categories, they're not going to be eligible to work out in the community. So no kidnapping, no homicide, no interstate compact, no sex offense, arrest, and no ICE detainer. Okay, here's where the programming part comes in. The corrections plan is a component of the classification system. So once an inmate's custody level is determined and they're moved to the appropriate unit or complex based on their custody level, they sit down with their correction officer 3 and they go over what their time in ADC should be like. And that includes all their individual goals, needs, objectives, programming, education, etc. Once that is determined, we have what we call a priority ranking report. We have 40,000 inmates. Not everyone, we can't program, educate, work all 40,000 inmates. So we have to rank them somehow based on resources. And I'll later on show you how we rank them. And then our Earned Incentive Program, EIP, reinforces to the inmate that, hey, you need to do this while you're in prison to have positive reentry back in the community, and if you don't do it, we're going to penalize you for it. So that's really what the EIP system is about. So basic correctional plan will determine an individual's service needs and all requirements, including medical, mental health, substance abuse, sex offense, work, education, vocational, self-improvement, and provides them a structured schedule to follow. So it's all entered into the computer. They're given their schedule and they're expected to follow it. Again, starting at reception, and then once they get to their unit, these are the different categories the correction plan looks at. So let's say the inmate doesn't have a GED. He needs mental health treatment. He needs self-improvement. We look at all of that and then we prioritize. That inmate's never going to get a job until he gets that GED. So he's not going to go work at ACI and make, what do they make now, 50 cents an hour? That's our highest paying job. Until they get that GED. That's the most important thing that they need to work on. So we try to rank what the need is. And obviously mental health is critical. So his two major goals is going to be get that GED and go to your mental health treatment. Work will come later, but you need to get this taken care of first. One of the big questions was, and we get it all the time, that inmate needs substance abuse treatment. Can we send him to Marana? Yes and no. All of our institutions, with the exception of Winslow and Safford, offer substance abuse treatment. Some is good or better than Marana. Marana has very strict criteria. It's really based on the community of Marana. When we first, it's a private prison, but the community was very, very upset when a prison was open there. So Marana is very restrictive. They have to be minimum custody. They can't have any property offenses that are a class 4 or higher, 3 or higher. No type of street gang or gang affiliation, no violent history. It's just very restrictive criteria to get into Marana. But all our other complexes offer it too. And the corrections plan will identify to us which inmates need that substance abuse treatment, and we'll make sure that if they're on that priority ranking that they need that substance abuse, we'll make sure they go to an institution that offers it. So we wouldn't send them to a Winslow or Safford. So they're going to get the treatment they need based on what our corrections plan is telling us. Now our internal for substance abuse treatment, we use 2 instruments, both evidence-based. One is the TCUD, which is a Texas Christian University instrument. That's a self-reporting tool, so the inmate is basically asked, you have any drug issues, et cetera, et cetera. The AZAHI, the Arizona Substance Abuse History instrument, is more of a questionnaire than it's scored. Those 2 together determine a substance abuse treatment needs level. Then we look at the, yes?
Occasionally, we'll look at a pre-sentence report where the guy says, I got no drug problem, but he has a rap sheet of prior drug offenses. So if the guy doesn't self-report or he answers the questions, I don't need no stinking drug treatment, what are you guys going to do?
That's where the AZAHI comes in. The TCUD is self-report. The AZAHI, we will extract information from PSIs, from criminal history, etc. So it will, because we know not all of them tell the truth when they come in. So that's why it's a combination of the 2. So then you have your treatment need level. And then obviously we're going to look at the time remaining to serve. If you have an inmate serving a life sentence who needs substance abuse treatment versus an inmate who's getting out in 6 months, we have very limited resources, very limited substance abuse counselors. So, you know, if we only have 20 seats available in a class, that inmate that's getting out 6 months from now versus the lifer is going to get put in that class first. And that's going to the two extremes, but that is taken in consideration in the priority ranking part. The final factor in the priority ranking is risk to recidivate. And that's based on an internal community risk tool that was developed by Dr. Fisher several years ago, again, evidence-based. So those 4 factors basically spit out a corrections plan to the inmate saying you need this, this, and this, and in what order, and you'll be eligible to get into sex offender treatment in 3 years because I have 100 more inmates getting out before you that need that seat first. So that's kind of how that's determined. So if an inmate gets moved, you know, to a prison that may not offer sex offender treatment, well, according to the priority ranking, he's not going to get it anyway. When he comes up, then we would move that inmate to the appropriate unit to ensure he gets into that class. Yes?
Do they have an opportunity to go back and self-report in a more honest and complete way? So when they come into custody, and maybe they're not quite as forthcoming, but after a couple of years of incarceration, they reconsider their need for substance abuse, can they go back and address that?
Yes, the corrections plan is reviewed annually. So once a year, that inmate is brought in, the counselor sits down with them, and they go over their progress of the corrections plan. At that time, that's where that dialogue would occur. And at any time we get new information, we can always go in and enter that, and it would immediately change that plan. And at any time the inmate can request, you know, to program or request to see his counselor. It doesn't have to be at that 1-year review. That's just the mandated review for the corrections plan. And again, I just explained the priority ranking report is basically that inmate's roadmap from the time he comes in to the time he leaves. Again, limited resources. We want to make sure we get the right inmate and the right program at the right time. So with 40,000 inmates and limited resources, it's not an easy task, but I think we're doing a pretty good job of it. So what incentives? Because a lot of inmates just refuse to program. They don't care. They don't want it. We know they need it, but they refuse to program. We created what we call the EIP, the Earned Incentive Program. And basically, it's a 3-phase level system that's based on privileges. When the inmate first comes in to Alhambra, they're in phase 3. Phase 3 is the most restrictive phase. And the privileges that the inmates receive are obviously recreation, visitation, phone calls, their pay, store, how much money they can spend in the store, etc. So when they first come in, it's going to be really restrictive until for about 6 months. It takes 6 months for them to progress to the next phase level, because we want to see what their behavior is going to be like. Are they programming like they're supposed to? So it's really more restrictive until we really know more about that inmate. If they're doing everything they're supposed to be doing and they're following that corrections plan, they can move to phase 2. Phase 2, they'll get more visits, they'll get more phone calls, they'll get more money for store, etc. And phase 1 is the least restrictive. So at phase 1, you get the maximum amount of privileges that you're allowed for the custody level you're in. Each custody level, you're allowed different types and amounts of privileges. If you refuse to program, or you get a discipline, or just showing overall negative behavior, we'll take those privileges away to the point where you may not get any privileges. You can earn those back, and it's really in 6 months reviews. So if you assault an officer or assault an inmate, basically you're going to max custody and you're not going to get anything except what's mandated by law. You know, your showers, your food, etc. If you prove in 6 months that you are behaving, then you may still be in max custody, but we may give you a phone call, or we may give you an extra visit, or whatever. So that's kind of how the EIP program works as an incentive. and it doesn't sound like much, but visits and money for store and phone calls are everything to an inmate. So it really does work with most inmates. There's some that no matter what you do, they don't care. You know, they're going to do what they want. They're happy in max custody. So it doesn't affect all of them, but I think the majority it does. Any questions?
Could you tell us a little bit more about the 90-day release? Like, are there certain offenses where someone is simply just not eligible? And is it basically at the discretion of DOC?
The temporary 90-day release is discretionary. There's basically, in statute, there's no criteria. So most of the criteria for a TR release is policy-driven, not statute-driven. The criteria that the department has set is, number one, they have to be medium custody or below. Going back to the sex offense statuses, that they're a sex offender status A through E, I think that's what it was, they don't get the early release. If you're a criminal alien, they're a separate group. They are eligible for a TR only if there's a detainer and ICE picks them up. They never hit the street. They go straight from the department to ICE. If they get to ICE and the judge decides that he's not going to issue an order of deportation, we have an agreement through our MOA that inmate will be brought back into prison until his ERCD. So he never hits the streets. Herbie, any other criteria? Custody, sex offender,
Detainers.
no detainers. If they have a felony detainer or what we call a felony hold, there are a lot of times through criminal history or just through communication with other law enforcement agencies where an inmate may be under investigation for some type of felony offense, a homicide, a murder in a lot of cases, but a detainer hasn't been placed yet. We'll still place what we call a felony hold because we don't want to let that inmate out. Just not good public.
This may be the topic next time, but on the 85% stuff, I have a couple questions on 85%.
That's probably a topic for next time, but if we have time, Herb's could probably.
One other question about the 90%. So a lot of the defendants and their lawyers seem to think that it goes by the felony class. Okay, well, if I have a class 2, I don't get 90%.
No.
If I have a class 3, I do get it.
No,
Is
it's not driven by felony class. Now, the custody level inmate, the felony class affects, but it's not independently a factor in release eligibility.
There's no direct connection.
No.
Okay.
The connection would be if it was a violent crime, not dangerous, as you put non-dangerous or non-repetitive, but if it's classified as a violent crime by the department.
Oh, but
then
that's
they
under
would
your
not-
criteria.
That's correct.
Okay.
Yeah,
That's correct.
yeah.
That would be an 85%, so to speak.
Yeah, they don't get the full 90 day, they have to serve a minimum of 85%, but again, that's department driven.
Okay. So how often, you may have mentioned this, but how often is the custody classification and the inmate risk reviewed, and can that be changed?
I did not cover that. The classification, the corrections plan is annually for programming, treatment, etc. The custody level is event driven. So basically the inmate comes into Alhambra and let's say he scores out as maximum custody. We had the non-discretionary overrides. So basically he's never coming out of max until he meets those guidelines. But let's say there's no non-discretionary. Each factor is scored independently, but as time goes on, our computer's constantly recalculating. And the age of the offense, the age of the disciplinary, the age of the inmate, all of that allows them over time to reduce that score in that individual category. When all those changes affect the overall custody level, it will send an appointment to the classification officer and say, hey, he's ready to reduce, classify him. So it's event driven. I come in and I'm minimum custody and I go, I get caught with a cell phone or I assault an officer or whatever, that if that disciplinary affects the overall custody level, it will immediately tell us, hey, he's not appropriate for minimum custody anymore, you need to reclass him. So it's what we call event-driven. There's some other guidelines, but basically, in most cases, it's event-driven.
And that would be reassessed every, like if somebody's going to prison again, then that's assessed.
Each time they come in, they get a brand new initial classification. The prior convictions is part of the scoring, but they're given a whole new classification.
Two questions off of the original sentence. You said that it takes the paperwork. I sentenced a guy this morning to 2 years in prison.
Okay.
I signed an order of confinement, and he goes behind the door, and I don't see him again. Then there's a minute entry that I would have signed his fingerprint page later tonight, so maybe it gets filed tomorrow or Wednesday. When will you take custody of this guy?
As soon as the clerk of Maricopa County calls me, when she gets your signed minute entry, I don't know how long they keep it, because there's other issues, specifically with the county jail, that you need to make sure all their medical stuff's ready. You know, there's other things. But from the time we're notified, so if Maricopa County clerks call me today and say I have 100 inmates to bring in, which they did to us today, which is never fun, I'm going to say, okay, bring them in tomorrow. My time frame is 24 hours.
And then once in the blue moon time, where I'm going to sentence somebody to a year, he's already done a year and a half. So he's looking to get out, but he still has to be processed by you. Is there any way we can grease it so that he minimizes his in-custody time?
Yes and no. If you basically sentence the inmate to time served, there's two different categories. If he does not have any community supervision, he can be released from the county jail if MCSO does two things for us: fingerprint and DNA. And right now, they're not cooperating with us, because we've had a couple that they're saying we're not doing the DNA, and per law, the DNA has to be taken. Is it possible? Yes, we do it. Yavapai, we do it with Yavapai all the time. Now, if he has community supervision, he has to come in, because we have to find a program for him through community corrections. So those are the yes. They can be, as long as the jail will do the DNA and fingerprints and he doesn't have community supervision.
So does that mean then that that's all you need in order to process this person if community supervision is waived and they go and they just have a probation tail? Those are the only two things that you need. They don't have to go through the entire assessment.
No, we need, obviously we need a minute entry, the certified court document, so time comp can verify it's time served.
Okay.
But yeah, no, they don't need to come in and go through classification and all of that. They can be released from county jail if the DNA and fingerprints are done.
If they aren't done and they have to go to Alhambra to have it done, are they in custody while they're in?
They are in custody. As soon as the jail drops them off, they're ours. But again, if they don't have supervision, we can usually get them out the same day. Because all we're going to do is swab them, print them, see ya. But if they need a program, then we have to work with community corrections to make sure we get an approved placement.
So whether it was accurate or not, I have previously heard they need a DOC number, so that's not really true.
It is, but we can do that from, the inmate doesn't have to be present to assign them a number. So it is true so there's a record of them being sentenced to DOC. They're going to get a number, but they don't have to be present in order for us to do that.
I made a mistake yesterday. Someone had anyway, the person had released because he'd served 135 days. It was an ag DUI. The step was to 4 months in DOC, then probation once that started. He'd served 135 days. He was out of custody. So what you're saying is I should have remanded him back into custody, even though he'd served his time.
Yes. Yes. And we need, we need a DNA, a fingerprint, and we need a record that he was sentenced to the department. So we needed to create a number and some type of record for him.
So he goes back in, even though he served all that time, right?
Yeah. We would have released him same day, but usually when that happens, the clerk will usually give us a heads up and say, hey, inmate's time served. We'll say, is there supervision? No. Will you fingerprint DNA? If they say yes, then the inmate can be released. If not, he needs to come in.
A couple of questions about education. A lot of the people we sentence are young, 18 or 19. Do they have, other than GED, do they have any opportunity to earn a high school diploma?
Not right now. Right now it's just the GED. We're looking at actually bringing in full high school courses, but we're not to that point yet. But right now we offer GED, special ed, and mandatory literacy. And we offer vocational classes through some colleges, etc. But right now it's basically just the GED.
So that was the other question. Say they get their GED while they're there, are they able to stay occupied with any education beyond that?
We have some vocational ed. We have a few college courses, I want to say, out of Safford through, I think it's Eastern Arizona Community College. We have some college contracts at some of the institutions. If you want to contact me, I can get you more information on that through our education department. But yes, there are some opportunities.
Just one more follow-up on remanding into custody to go to Alhambra. So I think I had talked to you about a case that I had, and the guy was out of custody. And I thought you had mentioned that I could order him to go self-surrender at Alhambra rather than having him go back into Sheriff Joe's jail.
Correct.
Now, so I write that on the minute entry.
Yes.
And then it goes to you. And what if he doesn't self-surrender? Who does something about that?
We would probably work with Maricopa County to issue a warrant on him.
Okay.
Yes.
So, but we wouldn't have, as judges, we don't have to monitor whether he
No.
actually self-surrenders.
No.
Okay.
To follow, I've not heard that. More frequently, we have a self-surrender with the jail. So we'll sign an order of confinement. So it's really not the minute entry; it's the order of confinement, and they got to show up on time when the jail. Otherwise, they won't let them in. It would be the minute entry that you guys would look at that he would need to bring to the Alhambra to show them, so that you guys let him in the door?
Yes, and we would also request that come to us too, so we're aware, because some of these inmates have very good fakes. We almost released an inmate several years ago that sent in a fake order to vacate, and it was a pretty good one because he was on his way out the door. So we would prefer that, just like the regular, it comes through our route, yes. And Maricopa County is the only county that we accept orders of orders of confinement in lieu of the actual sentencing documents. So, but yeah, that's all we would need with the fingerprint.
When you ask that it go through your unit, what do we need to do to make sure that happens? I mean, our clerks, I assume, just follow some standard process. Is this different from the standard process?
No, if that goes to the clerk, as long as, that should, the clerk still should send that because it's still a sentence of imprisonment.
Right.
So yeah, I don't think there's anything additional the judges would need to do.
We get emailed.
Yeah, they're.
The minute entries every day. We get
Yeah.
It's an automatic email from the database, I guess, of all the.
Yeah. So I don't think it's an issue. Yeah.
Okay.
Can we get a copy of the PowerPoint?
Yes,
Yeah.
I have. I'll send that out by email. Any other questions? All right. Thanks so much, Stacey.
Thank you.